Can you still recover money if you were partly at fault for an accident in Massachusetts? Yes, you may still be able to recover money, but in Massachusetts, there is an important limit to understand. If you are more than 50% at fault, you cannot recover. Welcome to Massachusetts Personal Injury FAQ. I'm attorney Tracy Paulsen, founder of Rightful Legal. Each week, I will answer common questions posed by my clients regarding personal injury. Massachusetts follows a rule called comparative negligence. That means fault can be divided between the people involved in an accident. One person may be mostly responsible and another person may be partly responsible. And the law looks at those percentages when deciding whether compensation is available. Here is a simple rule. If you are 50% or less at fault, you may still be able to recover money, but your recovery is reduced by your percentage of fault. If you are more than 50% at fault, you recover nothing. So for example, if your damages were $100,000 and you were found to be 20% at fault, your recovery could be reduced by 20%. That would leave $80,000. If you were found to be 50% at fault, your recovery would be reduced by half. That would leave $50,000. But if you were found to be 51% at fault, your recovery is zero. It's completely barred. That 1% can make a major difference. This is why fault is such an important issue in a Massachusetts personal injury claim. It is also why insurance companies focus so heavily on blame. After an accident, an insurance adjuster may look for anything they can use to argue that you caused or contributed to what happened. They may point to what you said at the scene. They may point to a police report. They may look at photos as evidence, vehicle damage, witness statements, or even your own medical records. Sometimes they may try to make your share of fault seem larger than it really was. That matters because every percentage point can affect the value of your claim. And once the insurance company can push blame over 50%, they may argue that you should recover nothing. In a car accident case, they may argue that you were speeding, distracted, following too closely, or failed to react in time. In a slip and fall case, they may argue that you should have seen the hazard, that you were not paying attention, or the condition was open and obvious. But those arguments are not always the final word. A personal injury case is about evidence. It's about what can be proven. It's about whether another driver, property owner, business, or company failed to act with reasonable care. And it's about whether that failure caused your injuries. So if you are partly at fault, do not assume you have no case. And do not let insurance companies decide the legal value of your claim before the facts have been fully reviewed by a personal injury attorney in Massachusetts. The key questions are: what actually happened? Who had the duty to act safely? How did each person contribute to the accident? What evidence supports your side? And how serious are the injuries and the damages? Comparative negligence can reduce a claim. If it's your fault is more than 50%, it can also prevent recovery completely. This distinction matters. The strategy is to investigate early, preserve evidence, and challenge unfair blame before it becomes the insurance company's version of the case. If you were injured in Massachusetts and someone is saying you are partly at fault, the real question is not whether blame exists. The real question is how much blame can actually be proven under Massachusetts law. If you have questions about your potential case or your rights, you can reach me directly at 617-821-5856. If you found this video helpful, please like or share. Thank you.